Good afternoon, everybody. Welcome to today's Holland & Hart Healthcare Compliance webinar series. Today we'll be talking about relevant laws for telehealth. My name is Christy Kimball, and I'll be presenting today. And again, we welcome everybody for joining us today for this webinar series. First of all, our standard disclaimer, just mentioning that this presentation is designed to provide general information on pertinent legal topics. It's for educational purposes only, and the statements made and information included do not constitute legal or financial advice, nor do they reflect the views of Holland & Hart or any of its attorneys other than the author. This information is not intended to create an attorney-client relationship between you and Holland & Hart. So moving on, I just wanted to mention before we get started the various other webinars that we'll be doing in this series. These show through the months of July, August, and then into September. We will be continuing this webinar series with various other topics. So we hope that you'll join us for those topics that are of interest to you. As far as like resources, when we do these webinar series, it can always be a little bit daunting, but we try and include for you a list of some of the relevant resources. You will be sent a copy of these PowerPoint slides after the telehealth, after this webinar series has concluded. But also there are some other good resources. Some of those include Kim Stinger, my colleagues, some of his various client alerts and resources, but also for telemedicine policies, there is an overview of each state's telemedicine laws, and you can access it via this link that we will provide that will be in the slide deck. So that can be a really excellent resource. That's done by a third-party entity, and normally they keep that pretty up to date. So that can be a nice little resource for you. So an overview with telehealth, if you're doing any kind of telehealth, any kind of a business model providing care via telehealth, there's actually a lot to consider. And so today we're going to be covering recent developments. You've got to consider licensure requirements, the scope of practice for telemedicine, the standard of care for telemedicine, remote prescribing, credentialing with hospitals, other entities, the corporate practice of medicine, HIPAA, privacy and security concerns, potential discrimination against patients with telehealth, liability concerns, fraud and abuse concerns, and reimbursement issues. So we're going to be covering all those topics today, so we'll have to go pretty quickly to get to all of that. As far as recent developments, as most of you know, during COVID, CMS and the DEA allowed for greater flexibility in receiving care via telehealth. Even though the public health emergency has ended, the DEA, jointly with Health and Human Services, has extended the current telemedicine flexibilities for controlled substance prescribing through 2025. They did this via a third temporary rule, so they've done this twice before. So currently that allows for Schedule 2 through 5 controlled substances to be prescribed via telemedicine without an in-person evaluation of the patient. But there are certain requirements, including that it must be for a legitimate medical purpose. You must use interactive telecommunication systems, and the practitioner must have DEA registration in the state where the patient resides and otherwise comply with state law. For example, again, have a state license in that state and a controlled substance license registration. CMS has kept certain telehealth coverage in place permanently as well, and we'll be covering some of those things. We will be touching on this a little bit later, but this current flexibilities by the DEA for controlled substance prescribing, that just goes through 2025, and there is a proposed rule that's waiting to go into effect. And so they're trying to keep these flexibilities in place until that rule can be finalized. But you need to keep your eye very closely on this development because as of the end of 2025, that temporary rule, the flexibility is scheduled to end. Also, as far as recent developments, there is OCR guidance concerning the use of telehealth platforms post the public health emergency, and flexibilities regarding audio-only telehealth. The Department of Justice has issued guidance concerning discrimination in telehealth, and state legislatures and licensing boards have kind of frantically addressed the issue of telehealth over the last few years. So almost every legislative session in each state, there will be state laws, or you'll see the agencies updating their telehealth rules, you know, on a very frequent basis. Whereas before the public health emergency, we didn't see that much room. We didn't see that much activity in this space, but there's been a lot of activity since. So you've really got to keep a close look at what's happening in the states. So to that point, just showing telehealth rules, it would be nice, right, if we had one standardized rule or law that applied to how telehealth can be conducted. However, this is, outside of CMS and reimbursement issues, this is governed by state law. So every state's going to have its own rules related to telehealth and what qualifies as valid and compliant telehealth. So there is no comprehensive or coordinated national law. Federal agencies also may have certain requirements, like we just mentioned, Medicare, the VA, DEA, FDA. Each state has its own requirements. So in terms of whether or not you need a license, whether or not they have a special license for telehealth, the telehealth standards that are required, remote prescribing, reimbursement, etc. And different licensing agencies within that state also have different requirements. So for example, your state medical board will have different rules for telehealth than that for physician assistants or nurse practitioners or psychologists, social workers. So not only is it, it's confusing enough that you have to look at state by state laws, but then in relationship to those medical providers that are providing the telehealth, you have to go deeper and look at each of their specific requirements for telehealth in their specific licensing laws and rules. And then, of course, each payer generally has their own requirements for reimbursement of telehealth services. So you just absolutely have to check the law in the states where you intend to provide services and make sure that you are complying with each of those states' laws. Like I mentioned before, this is a great resource that you can use, the Center for Connected Health Policy. They generally at least have a good overview of the summary of federal and state laws related to telehealth. So you should start there in terms of trying to get yourself at least oriented to the general and basic laws in each state for telehealth. So what is telehealth? I mean, generally that means the provision of clinical services to patients by healthcare professionals from a distance via electronic communications. And there are different types of electronic communications. There's simultaneous, synchronous, or real-time, non-simultaneous, asynchronous, store and forward, etc., or remote monitoring. And each of those state laws and then these state rules for each of the professions will normally address what they consider to be valid telehealth services. And especially you're going to see for those third-party reimbursers, the insurance companies, they're going to be very specific about what counts for what kind of technologies need to be used in order for them to pay for services. Usually telehealth does not mean communication via phone, email, etc., but there are some instances in terms of like telephone where that is acceptable now. So you've just got to check applicable state law and payer definitions to determine what is required. And especially when it comes to payers, that's going to be incredibly important, because if you use a methodology that they don't allow and you bill for that, technically that is not something you're allowed to do, and they certainly can claw back. And if you're doing that and knowingly doing it, that can even amount to fraud. So let's talk about originating in distant sites. So in these laws, when it's taught, normally it's going to be talking about the originating site and the distant site. The originating site is where the patient is located, including the patient's home. And the distant site is where the remote practitioner is located. And of course, that telehealth provider communicating with the patient at the originating site is what constitutes telehealth, so long as it complies with, again, the other state laws and the requirements of the payer. So in terms of being aware of the applicable law, as a general rule, the telehealth provider must comply with both the law of the state in which the telehealth provider is located and the law of the state in which the patient is located. Of course, states want to protect patients, and there are likely sufficient contacts to establish jurisdiction over that telehealth provider. So even if you feel like, well, I can do this, I'm not licensed in that state, what is that state licensing board going to do? Again, likely the fact that you're treating patients via telehealth in that state is going to establish enough contact that the state can have jurisdiction over you. So again, what are the things that we've got to think about? Licensure, permissible telehealth methods, provider-patient relationships, scope of practice, standard of care, informed consent, remote prescribing, etc. So let's jump in and go a little bit deeper. Before we do that, I want to mention, not that we're trying to scare you, but so often we have clients that jump into this space and just aren't aware of the potential issues, and they can be a little bit naive, and only thereafter, when things go very, very badly for them, do they, often get attorneys involved, only when they have to. And of course, we never want to see, clients in that position, but there can be civil or administrative penalties for violations such as adverse licensure action, denial of reimbursement or repayment, False Claims Act liability, repayment, civil fines and penalties, qui tam litigation. You can be excluded from these payer programs. There's malpractice when there's violation of state law, which may constitute negligence per se, loss of insurance coverage. When it comes to the criminal aspect, though, that's the worst case scenario, of course, that you can be charged with practicing without a license in that state, false claims fraud, wire fraud, and those can lead to potentially prison, fines, being excluded from participation in Medicare or Medicaid, or having your Medicare and Medicaid billing privileges revoked. So there can be really serious implications for violating these laws. So let's turn to kind of start going down that list of these legal issues you need to be aware of. So licensure. States regulate the practice of professions, so medicine, nursing, therapy, counseling, etc. So for example, the practice of medicine may be defined as to investigate, diagnose, treat, or prescribe for any human disease, ailment, injury, or other condition, to offer, undertake, attempt, or hold oneself out as able to do any of the foregoing. Unauthorized practice of medicine is usually a felony in most states. So there are criminal consequences. There could be prison and adverse licensure action. And there's similar penalties applied to other professions. Again, you have to look at each state's laws to determine exactly how they define the practice of medicine, and make sure, if you're not licensed in that state, that you are not doing any of those things that count as the practice of medicine. And sometimes those can be really unique. In Utah, we have something where it says that if in any public way, you're holding yourself out as an MD, so if you've got that behind your name and you're kind of holding that out to the public, that constitutes the practice of medicine, in the state of Utah. So even using those acronyms, behind your name can constitute that. So you've got to look at the state law and figure out what constitutes the practice of medicine in that state. States generally require that providers rendering telehealth be licensed or registered in the state where the patient is located. Most require full licensure. Some permit a license from a bordering state. Some allow a special purpose license, for example, just a telehealth license. Some allow limited practice within the state for consultation or education. Some allow for expedited licensure, such as when they respect the Interstate Medical Licensure Compact. Also, there are usually exceptions for practitioners in the military, VA, public health service, may practice within their organizations across the states. But again, you've got to look to the state law to determine what is allowed without a license, and then what specific licenses are available and how quickly they're available to you to engage in the practice of medicine via telehealth in their state. Again, this is a really great resource where you can, we've given you this URL so you can put that in, and it will go through and gives you a very high level overview of whether or not a license is required in that state. As far as for state Medicaid, what type of telehealth is required to be provided for Medicaid to reimburse, and whether or not there is a private payer law that defines what valid telehealth is in that state. And then they do have some links to the applicable code. So be sure to use that resource. Let's turn now to hospital conditions of participation for Medicare. So when it comes to Medicare, there is, for hospitals as a condition of participating in Medicare, they specifically require that the physician has got to be licensed in both the state where the practitioner is located and the state where the patient is located. For critical access hospitals, the conditions of participation state that each physician or practitioner who provides telemedicine services to that facility must hold a license issued or recognized by the state where the critical access hospital is located. So there's a little more flexibility for these critical access hospitals, understanding that they have more limited, resources than a normal hospital. Medicaid. So most state Medicaid programs require that the provider is licensed within the state as a condition for reimbursement. Medicaid guidelines require all providers to practice within the scope of their State Practice Act. So states should follow their state plan regarding payment to qualified Medicaid providers for telehealth services. So again, they're going to have unique requirements, state Medicaid programs, in terms of what kind of telehealth is valid for them to reimburse for that, whether it has to be a live interaction or whether or not it could be store and forward or some other form of telehealth. But normally they're all going to align in terms of the scope of practice. They're going to say that whether if you're a physician, if you're a therapist, whatever kind of provider you are, that you've got to align with your state's scope of practice within your applicable licensing act. So outside of Medicare, Medicaid, every state, if you're going to practice telehealth, you've got to comply with the scope of practice laws in the state where the patient is located. Usually, in most states, the provider's scope of practice for in-person care also defines their scope of practice for telehealth care. So if you can provide the service in person, they can provide the service through telehealth. Any limits that apply to the scope of practice for in-person care also applies to telehealth. But again, there are going to be some nuances depending upon your particular practice area and your particular licensing law and applicable rule in that state. So you've got to consider, right, scope of practice, the requirements for non-physicians. Like I was saying, these other types of practitioners, PAs, APRNs, RNs, therapists, they may limit the scope of practice for telehealth or otherwise. For example, for, let's say, a physical therapist, right? Are there certain things that they just can't properly help the patient with when they're doing it in a remote way? Each state is going to decide for themselves what they think the applicable scope of practice is for each type of licensure. But states may require certain supervision by a physician or other provider licensed in the state where the patient is located. While we've seen lately a lot of increased ability for PAs to practice independently, usually there's going to be some kind of supervision or a need for a collaborating physician licensed in the state. For APRNs, it may require supervising or collaborating physician. That's far more rare than with PAs, but in some states that may still be applicable. And RNs generally are going to require supervision or direction from a licensed independent practitioner. So let's move to the provider-patient relationship. All the states require that the telehealth provider establish an appropriate provider-patient relationship. But these state laws and rules, they differ in the manner in which the relationship may be established. Whether that has to be in person, the use of telehealth, does that have to be, if they can do it via telehealth, does it have to be synchronous versus asynchronous? Does it have to be a two-way audio visual versus audio only? Do there have to be periodic in-person encounters? So some of these states will say that, you know, you can establish it in a certain way, but you've got to see the patient in person every so often, even if you see them via telemedicine. You know, in the interim periods, there have to be certain in-person encounters. There may be other methods that satisfy the standard of care. And some states, including Utah, require certain disclosures to the patient for telehealth in regard to their licensure, their credentials, their location, identifying, you know, making sure that the physician knows in that patient's state where that patient can access like emergency services, whether or not the telehealth provider has to provide medical records to the patient's primary care physician. There are a lot of unique things in every state law generally about what's required for that provider that's providing telehealth. So again, you've got to look at the state law. And this isn't insignificant, just by way of a little bit of warning, you know, people do have their, you know, license threatened for improperly providing telemedicine in a state in which they're not licensed. And this is just a little headline of a physician back in 2015 in Idaho, where she was providing telehealth in Idaho, and just prescribing, I think it was in this case like an antibiotic through a telemedicine company, and was hit by the Idaho State Medical Board with practicing medicine without a license. So it can be incredibly jeopardizing. So you want to be careful, you know, as you approach providing telehealth in each state to make sure you're aware of the applicable laws and comply with them. Let's turn to the provider-patient relationship. So most states have exceptions to the requirement for existing provider-patient relationship. So we've already kind of talked about, you know, that every state, right, you've got to establish a proper provider-patient relationship, and every state laws are going to define what that means and how you can do that. But most states have an exception. So for example, some states will have a carve out if you're covering for another member, let's say another physician of the same group that has already established that provider-patient relationship. If you're covering call for another provider with an established provider-patient relationship, initial admissions or necessary care pending the first appointment. If it's an emergency, if you're providing a consultation without charge, so you're not making any, you know, money from this. And then there are other exceptions. So you want to be very well aware of those exceptions to those requirements for providing a patient relationship. Informed consent. The telehealth provider must generally obtain informed consent from the patient or their personal representative. Some states have very specific requirements for telehealth consents, such as written documentation of informed consent, specific information that must be disclosed, such as the provider licensure info, risks and benefits of telehealth, how to contact the provider. Again, you've got to just look very carefully at that state law. The treating provider usually has the obligation to ensure sufficiently informed consent is obtained. So even if you're working on behalf of a provider group, a hospital, it doesn't matter if, you know, you think, well, hey, wait a minute, I was relying upon them to get this informed consent. Normally, it's the treating provider's obligation to obtain that informed consent. And if you don't get it properly, it's your liability as the provider. It's not the entity. So you want to make sure as the provider that you're very careful about obtaining proper informed consent. In the telehealth context, consider discussing the patient's condition and proposed treatment, the risks and benefits of treatment, alternatives and risks and benefits of alternatives, the person's entities providing services, the limitations of telehealth, so limited evaluation or treatment, possible disruption, privacy or security concerns, disclaiming liability for contractors, and other relevant facts. Okay, turning to the standard of care now. In most states, telehealth must be provided consistent with the in-person standard of care. So normally there's no special telehealth standard of care. So you've got to ensure that telehealth is appropriate under the circumstances and that you can satisfy the community's standard of care. Generally, if you feel like you cannot ensure the appropriate standard of care in providing some kind of treatment, care, consultation via telehealth, then it probably is not something that you should be doing because it's going to put you at risk. To meet that normal standard of care, it typically requires appropriate history, evaluation, diagnosis, and a treatment plan. Normally, an online questionnaire is insufficient, although I will say that in some states like Utah, there are very limited things where, an online questionnaire could be sufficient for, let's say, prescribing certain medications, but it's very, very limited. And normally you have to, like in Utah, you've got to be enrolled as a physician that's providing these certain, let's say, cosmetic, medications online, and you've got to follow very specific practices that are set out in the statute. So questionnaires are going to be very, very limited, online questionnaires as being sufficient. But again, you've got to know your state law. You've got to have appropriate follow-up, document the care rendered and maintain documentation in the patient's medical record, and involve or refer to other providers where appropriate. The AMA does have a documentation for what they believe is the ethical practice in telemedicine. So there are some bullet points I've listed here for when the American Medical Association, where they say you should be looking at to see if telemedicine is appropriate. And we've included a link to that for that ethics opinion so that you can be aware of that. The one thing to think about in this regard too is that almost every state medical act or their accompanying rule incorporates the AMA's code of ethics. So if there is an opinion about this with the AMA and you violate it, technically that state licensing board can take action against you for violating one of the AMA's code of ethics. So keep that in mind. And then there is the Federation of State Medical Boards, and they've got the appropriate use of telemedicine technologies in the practice of medicine. So that's also another helpful resource to understand what they come down on as far as the appropriate use of telemedicine. Okay, so let's now turn to prescribing. Many states impose requirements for remote prescribing, requiring establishment of a physician-provider relationship. Historically, that's required in-person interaction. Now, most, if not all, the states allow a provider to establish a relationship through telehealth platform. But again, with some exceptions, online questionnaires are normally insufficient. But again, we've talked about that there are usually exceptions, and there are some of those, shown below that we've already talked about, including when you're covering call for a provider that has that provider-patient relationship, emergencies, etc. But turning to federal law in terms of controlled substance prescribing. So the Ryan-Haight Act is a federal law that generally in the past has prohibited providers from prescribing controlled substances via the internet without having previously informed performed an in-person medical evaluation of the patient. In general, that law says there are exceptions if the prescribing provider is temporarily covering for another provider with a treatment relationship, or the patient is being treated in a DEA registered facility. The provider has DEA registration in the state in which the patient is located, and the provider renders telehealth through two-way interactive audio and video communication system. Now, as most of you know, during the COVID-19 emergency, the DEA allowed remote prescribing following an evaluation through telephone or interactive audio-visual communications. So let's talk about I mentioned it briefly at the beginning of the webinar, but the DEA has proposed rules to allow for telehealth prescriptions without an in-person evaluation for a 30-day supply of a Schedule 3 through 4 non-narcotic controlled medications and a 30-day supply of buprenorphine for treatment of opioid use disorder. However, that rule and these rules have not been finalized. And so meanwhile, the DEA and Health and Human Services at the federal level, they've extended the current telemedicine flexibilities for controlled substance prescribing through 2025. And that was via a third temporary rule. So since the COVID-19 emergency has ended, they've had to do this now 3 times to extend these flexibilities because these proposed rules have not yet been finalized, and they don't want to leave this gap in the meantime. So right now, the current, via this third temporary rule, again, it's only through 2025, so they would have to do another temporary rule at the end of 2025, or these DEA rules would need to be finalized. But right now, through 2025, this third temporary rule allows Schedule 2 through 5 controlled substances to be prescribed via telemedicine without an in-person evaluation of the patient. Again, so long as it's for a legitimate medical purpose, you've got to use an interactive telecommunication system, and that practitioner must have DEA registration in the state where the patient resides and otherwise comply with state law. So if the state law requires them to be licensed in that state and have a controlled substance license or registration in that state, then they've got to have it. Also, keep in mind there's the Remote Prescribing Support Act, which facilitates telehealth for substance use disorders by the DEA. It requires the DEA to establish a telehealth registration process to facilitate prescriptions for these substance use disorder, patients. Now, there's while the Support Act was passed, and then every year via the Medicare's physician, their payment rule for that year, there are different specifics about the implementation of that for the year and how physicians can be paid and how providers can be paid. There is still an outstanding rule. There's been a proposed rule that requires this new registration process for the DEA to establish, but that has not been finalized. So at some point we're hopeful that there will be very specific telehealth registration processes that the DEA will put in place that makes it a little bit easier, but those have not been finalized yet. The Support Act does require state Medicaid programs to allow for prescription of controlled substances to substance use disorder patients via telehealth, and for Medicare beneficiaries allowed to receive telehealth in their home. And home is an approved originating site. I've got the citations down below regarding that Support Act, but every year it receives basically like funding, and there are little tweaks that you've got to look at in terms of reimbursement. Continuity of care. So once established, as providers, you all know that you've got to provide continuity of care. And once you've established that provider-patient relationship, that continues until you've properly terminated that relationship. And you've got to provide notice plus sufficient time to transfer care plus the necessary care until the patient can properly transfer to a new provider. The failure to do that can equate to professional misconduct, patient abandonment, and malpractice. So you really need to clarify scope of care and confirm expectations for continuing care as part of your telehealth obligations to patients. Let's talk about credentialing and privileging, which is only going to be relevant for some of you. But for those of you that do have privileges at a hospital and want to provide telehealth within the hospital setting, hospitals must credential and privilege providers rendering services at the hospital. For telehealth providers, the hospital's board may decide whether to credential them individually like other providers or by proxy if certain conditions are satisfied. Credentialing by proxy only applies to those rendering telehealth. It does not apply if telehealth providers render services personally at the hospital. Credentialing telehealth by proxy. So hospitals and critical access hospitals, the conditions of participation allow hospitals to rely on credentialing done by a remote hospital or entity. That's what it means to do credentialing by proxy. If the hospital bylaws allow it, you have a written credentialing agreement with distant site that contains required terms. The distant site complies with the condition of participation standards, and the practitioner is privileged at the distant site. The practitioner is licensed in the state where the services are provided, and the hospital reviews the practitioner's performance and provides results to the distant site. So just something to keep in mind for those of you that are affiliated with hospitals. So this slide is talking about the hospital condition of participation survey procedures, where if surveyors come in, for Medicare, these are some of the questions that they're going to ask to make sure that you're compliant with these COPs. I'm going to skip this slide, but if those of you that are affiliated with hospitals and will want to look at that. Keep in mind that credentialing of telehealth providers, hospitals may need to update medical staff bylaws or policies to address telehealth. That includes determining which medical staff members qualify for telehealth based upon which practice areas and privileges are appropriate to provide those services via telehealth, what categories of medical staff members it's appropriate for them to provide telehealth, privileges, whether or not you're going to grant telehealth privileges by proxy consistent with the COPs or otherwise go through the full privileging process, and then updating the credentialing process to comport. So again, this is just talking about critical access hospitals. Since it probably applies to so few of you, I'm going to skip this. Let's turn now to the corporate practice of medicine. So if you are going to be starting any kind of telehealth company and providing services via telehealth, one critical thing is to consider the corporate practice of medicine doctrine. So what this says, what this generally is that in some states, physicians may not be employed by companies, by corporations. And the main concern for this and why these laws were put into place is that it's a concern that non-physicians may influence physician conduct. So medical practices acts interpreted to prohibit corporations from practicing medicine through employed physicians. These statutes prohibit physicians from practicing medicine as an employee of a corporation. So this includes some of the states. You have to go state by state to know which states preclude this corporate practice of medicine. But California, Washington, New York, and Texas are among those states that preclude this. And so what it in essence means is that you cannot have a non-physician that has any ownership in a physician practice. In reality, that's what this comes down to, because the states feel like the non-physician owner would be motivated by making money rather than making sure that they are providing care that's in the best interest of the patient. But there are very specific things that you have to do in terms of setting up your company in those states that preclude this corporate practice of medicine. And if you don't comply with those state laws and how you set up your businesses in those states, the penalties may include fines, criminal penalties for aiding and abetting the unauthorized practice of medicine, adverse licensure actions, or injunctions to stop the practice from engaging in business. Usually, they're subject to exceptions. So these statutes related to the corporate practice of medicine expressly allow or contemplate that certain entities may employ physicians, like hospitals, managed care organizations, or other licensed entities, professional corporations, professional liability companies. The corporate practice of medicine usually does not apply to independent contractors, and it usually does not apply to advanced practice professionals. So you've got to be really, really careful. So for physicians and corporations that employ physicians, you've got to be aware of the corporate practice of medicine doctrine when practicing across state boundaries. And you need to be aware too that in some states, this applies not only to the practice of medicine, but they will have other healthcare professions that are precluded from kind of engaging in the same kind of behavior. So privacy and security. When you're doing telehealth, you've got to be cognizant of the HIPAA privacy rules so long as it applies to you. Assuming that it does, you've got to provide notice of privacy practices. You do not need to specify telehealth in those notice of privacy practices. You've got to verify identity of the participants in that telehealth. Implement reasonable safeguards to minimize risk of improper access or disclosures, such as having private rooms if reasonably available, conduct discussions in a manner to avoid others overhearing, safeguard records, and note that incidental disclosures are not violations or breaches. So, when you're doing telehealth, asking the patient if there's some place that is private and if they're comfortable that they're in a place where, no one's going to overhear anything that they don't want to be overheard. And then that you've got to do the same too. So those are things to just think about. Also, when it comes to the security rule, you've got an obligation under HIPAA to protect electronic protected health information. You've got to protect the confidentiality, the integrity, and the availability of that electronic PHI. So under HIPAA, you've got to do a risk assessment. You've got to implement safeguards. Those are administrative and physical safeguards. Ensure you are using a secure platform for HIPAA. And you need to look at the technical aspects, including encryption. And then for any downward stream vendors that you're using that are going to be able to access, process, etc., your protected health information of patients, you've got to make sure that you have properly executed business associate agreements in place. Be aware that the Office of Civil Rights in 2022 issued guidance regarding audio-only telehealth, talking about that it must comply with the HIPAA rules. So we've included a link to that. So be cognizant of that and read more on that by using our link. I think this skipped a slide. Communicating by email or text. So in general, under HIPAA, PHI must be secure, meaning it's got to be, this data's got to be encrypted. If you're going to be using email or text, those are generally not secure. So to patients, you can communicate via unsecure email or text if you've warned the patient and they choose to receive information in this unsecure manner. So normally that's going to be like in the patient intake forms. Normally we have things that we're going to draft in there where they we state that they recognize that these are not secure methodologies, and we have them select if they want to receive, email and or text messages despite their knowledge thereof. In terms of to provider, staff, or other third parties, you've got to use a secure platform. So you can't, they don't get to waive that, right? So if you're talking to other providers about a patient and their care, or to staff, you don't get to waive that requirement. You've got to use a secure platform. Orders, Medicare conditions of participation for coverage generally prohibit texting orders. And there was a CMS letter dated 12/28/17 that you can locate and read more about that in terms of, again, orders needing to be sent through a secure communication platform. So business associates, other treating providers are not business associates while providing treatment. They're covered entities as well, right? And they have separate HIPAA obligations. But you may need a business associate agreement with vendors or others who assist with telehealth, such as an entity that maintains or transmits ePHI and has regular access to ePHI. And that's not a conduit. There's a conduit exception under HIPAA. That's someone that's just kind of normally, they're the conduit for transmitting, information, and they do this in the regular course, but they're not somebody that has any substantial, touch point with that ePHI. And there are very specific rules about who qualifies as that conduit for that conduit exception. So if you have questions about that, you can reach out to us. An entity that stores your PHI. So a lot of people will, for example, your EMR vendor, right? They're obviously storing your PHI. You've got to have a business associate agreement with them. Some people have, for former patients, they have third-party companies that store their medical records, like their old medical records. Those are the kind of people that you've got to have a business associate agreement in place with. What are the exceptions? We talked above about, again, other treating providers are not your business associates. They're just covered entities themselves. But the exceptions are going to be members of your workforce. You don't need a BA with members of your own workforce, and members of an organized healthcare arrangement. And that is a very specific definition, and we've given you the citation to that. Like I mentioned before, the Office of Civil Rights did issue alert regarding and guidance on non-discrimination in telehealth and federal protections to ensure accessibility to people with disabilities or people with limited English proficient persons. So there's a link to that guidance, and it would be good, for those of you that commonly are doing telehealth, to thoroughly read that. This is just a summary of what that guidance was showing. That, persons with disabilities, you shouldn't be discriminating. You've got to provide reasonable modifications and effective communication. And for limited English proficiency, you've got to provide meaningful access. That means language assistance services. But there are specifics to when that applies, and, making sure that you do provide this accommodation where necessary. And so you should, carefully read that guidance to understand when it's applicable to you. So per this OCR DOJ guidance, examples of necessary accommodations might include intellectual disability, offering more time for a patient and providing a support person to assist during the encounter, the deaf or hard of hearing, providing sign language interpreter during encounter, using a platform that provides real-time captioning for the blind or those that are blind or visually disabled, ensuring recommendations are screen reader capable, and use video with audio descriptions. But again, read more, read the full guidance at the link to better understand that. And I'm going to skip past this because we've only got about 10 minutes. So in terms of liability issues, different laws. If you're crossing state boundaries, assume that you will be subject to the laws of the other state. And that's really everything. If you're practicing in that state via telehealth and you're treating a patient in that state, you're going to be subject to the laws of that state. So we've just listed out, again, some of those, the list of those laws that you need to be cognizant of, and you've got to know them and be prepared to comply. If you're crossing state boundaries, you could be sued in the other state's court or federal court under different procedures and standards. So you've got to be, prepared for that and cognizant of that. The practitioner-patient relationship, it may exist even though there is no direct contact. And normally the test would be, would a reasonable patient believe that a practitioner-patient relationship exists? Was there direct contact or communication with the patient? Was there a contract or agreement to provide care? Was there billing for the services? And again, some states have an exception for consultations if certain standards are satisfied, such as no direct contact with the patient, no bill for services. So be really cognizant of that. Some of these telehealth models that you'll see, the practitioner has very little or sometimes no communication or contact with the patient, but there's somebody else, maybe that you're supervising that has that kind of contact. But that doesn't mean that that state wouldn't see that a practitioner-patient relationship was established that could then make you liable for their care and under state law. Also, keep in mind patient abandonment. For those of you that are practitioners, you're very well aware that you can be liable for abandoning a patient if you fail to give a patient sufficient time to transfer care. And normally there's tort liability for this. And there also is normally under your Professional Licensure Act or accompanying rule, it will be a violation of that as well. So to avoid potential abandonment claim, ensure the patient understands the scope and limits of the practitioner's involvement in care. That should be part of the informed consent and any written agreement or notice. Give patient adequate notice and time to transfer care before terminating the relationship. So be mindful of that. A lot of times I think people want to engage in telemedicine, have very little contact, provide whatever care. In this day and age, you see a lot of, let's say, semaglutide. You see a lot of the weight loss drugs being prescribed via telehealth. And a lot of people want to make money from that, but they're not thinking about all of these aspects of practicing within that state and all these risks that still apply, even though you're, limiting your practice relationship and your provider-patient relationship to just one aspect of their care. That's still making you liable for all the things that you normally have to do when it comes to treating patients. So don't forget about patient abandonment. Malpractice liability, think about the applicable standard of care. Different community standard may apply. Normally the standard of care is based upon the community and when you're practicing. So with telehealth, right now, what is the community standard when you're practicing via telehealth? If you are located in a rural place in Utah, but you're providing telehealth services to somebody located in New York City, likely that community standard is going to apply to the standard of care. So you've got to really be very cognizant of that. Beware, is use of telehealth appropriate for the patient's care? Is there sufficient telehealth equipment or technology, training and qualifications of users, effective other laws, vicarious liability for others, including remote practitioner and originating site personnel. So think about who you're doing this with and make sure that you feel confident that those other people, the remote practitioner that's on the other site, let's say that's with the patient, or the originating site personnel, make sure that you feel good about their competence, because you could end up being liable for their acts as well. Make sure you've got good liability insurance coverage. Normally that's going to require proper license in order for them to cover you. So if you're practicing, if you're seeing a patient in a state where you are not properly licensed and you get sued, Normally, there will be an exception where they are not going to provide coverage. They're normally going to have carve-outs for the unauthorized practice of medicine, legal actions due to the unauthorized practice of medicine, such as administrative or licensure actions, criminal actions, for you practicing medicine in another state, for regulatory violations resulting from telehealth, such as violations of HIPAA, FDA violations. So you've got to closely look at your malpractice insurance coverage and make sure that you're complying with the requirements and make sure that your coverage is sufficient for what you're doing via telehealth in these other states. Negligent credentialing. In some states, hospitals or other providers may be liable for negligently credentialing those granted privileges. In Utah, by statute, such a claim is not allowed, but in many states it is allowed. And so if you fail to properly credential a practitioner, then the facility that credentialed them can be sued if there is patient harm as a result of that negligent credentialing. So it's just unclear at this point whether or not the conditions of participation or credentialing by proxy would satisfy a tort standard for proper credentialing. So be cognizant that, even though Medicare allows that credentialing by proxy, that may not make you immune from a negligent credentialing claim. There are fraud and abuse claims, False Claims Act, or fraud claims based on failure to comply with telehealth billing rules. So if you are not complying, especially with Medicare and Medicaid rules for when you can bill telehealth, and you are doing it knowingly, especially, you can go to prison. There are criminal aspects to this, so it's really important to comply. You may have financial relationships with telehealth providers, may trigger stark anti-kickback statute and civil monetary penalties. I'll give you an example. There have been a lot of online programs where, let's say, for durable medical equipment, where telehealth providers, these companies, have been contracted and paid for by either the DME company or by a marketing company that is associated with the DME company, where they are, let's say, telling patients, hey, we'll go ahead and connect you to a telehealth provider, and they will evaluate you and order the DME, assuming that it's appropriate. And don't worry about paying for that. We'll pay for that. You don't need to pay for this telemedicine provider. Under Medicare billing rules, the only person that can order, let's say, labs or DME, that has to be the patient's treating provider. That's got to be somebody that has an established relationship and is going to take the results of, let's say, those lab results, or understands what the patient needs and will be consistently seeing them thereafter. So a telehealth provider that has a one touch point with the patient does not satisfy that. And so technically you're not supposed to bill Medicare for those services, but also having a third party pay for the telehealth services is an absolute no. That should never happen, because that is, inducing somebody to receive these services. So if you're working for a telehealth provider, another entity, be cognizant as to whether or not you feel like they're being compliant and with these laws, because you will see a lot of physicians that unknowingly are trying to pick up some side work and go to work for these companies that are definitely not complying with the law. And you could be implicated in that and face even criminal charges if you continue to associate with them and provide these telehealth services in violation of the rules. So be aware, again, that the DOJ, in lots of scenarios, they do, target these telehealth claims because of concerns about fraud and abuse, similar to what I was just talking about. There's lots of different ways that you see telehealth being abused to try and fraudulently bill claims to Medicare, Medicaid. So, be on your toes when it comes to that. Um, we gave you a few different alerts, and then some of these kind of go over exactly what I was talking about, but just you can look at those alerts and be cognizant of that. In terms of reimbursement, reimbursement varies by state and by provider. You've got to check with your payer and your billing experts to confirm reimbursement areas. We're getting you a link to currently covered telehealth services. But be aware, right now we're at 1 o'clock. So I'm going to kind of go through the rest of these really quickly. But during COVID, Medicare did relax many of their normal requirements for their originating site. And some of those have been permanently changed to provide more flexibilities. And some of those have ended. And so you really should visit this link to read the latest on CMS's payment policies for telehealth, because there has been so much in flux over the last several years. And I know that it's confusing, but this will help guide you. And so we're giving you resources to find that. But there have been some permanent changes that are really helpful. And we've outlined those in this slide here. And again, giving you the link to that. There are some temporary Medicare changes that are supposed to end September 30th of this year, especially as it relates to behavioral and mental health care. So make sure if you're in that space that you're very aware of what the law allows and the fact that we've got this September 30th deadline for when that will end. We've also listed what the permanent Medicare changes are as of now. But again, I think we'll continue to see some changes here. Medicaid, we've kind of talked about that. Make sure that you look at the relevant laws. And then also be aware that for private payers, most states have some kind of parity law that says that with private insurance, if they insure certain face-to-face consultations, and they've got to cover it being provided via telehealth, as long as it meets the same standard of care. But it may not require the same level of reimbursement as in-person care. And so just be aware that usually there are, parity laws, and this map shows you what states have a parity law, whether it's full coverage or partial coverage, and whether or not it covers full coverage and payment. So that really concludes the presentation for today. We do have, and I'm sorry that I kind of skipped some of those slides, but I think we definitely hit the most salient points. Remember that we are giving you a lot of different resources in this slide deck that will help you to try and have a high level understanding and track some of these most important aspects of telehealth and billing and reimbursement. We're so happy that you could join us today. If you have any questions, please feel free to reach out to me directly via email. You've got my information there, and the slide deck will be sent to all of those who participated in today's webinar. With that, I hope that you have a wonderful rest of your day, and thanks for joining us today.